The market capitalization of the coin is used to summarize all that is taught in this video. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Take a look at this now, shall we? Ripple Labs legal chief warns plea to the SEC has the potential to spark a revolution in the cryptocurrency industry. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. As Ripple Labs prepares to appeal a ruling made by a federal judge regarding XRP, Chief Legal Officer Stuart Alderoty feels that the Securities and Exchange Commission is on the approach of facing yet another high-profile failure. This is because the SEC is already in the process of appealing the verdict. The SEC will be subjected to an unfavorable conclusion as a consequence of this appeal, according to Alderoty, who disclosed this information in a recent interview. According to the chief legal officer of Ripple Labs, he is content with their case in the Southern District of New York, and he is even more content with the fact that the company is moving on to the Second Circuit. Both of these things are good news for the company. In the year 2020, when the Securities and Exchange Commission (SEC) initially filed a lawsuit against Ripple and two of its executives, Ripple made it very clear that the legal war it was engaged in was not just for itself but for the entire industry, as Alderoty described. Ripple's actions were in response to the SEC's initial filing of the complaint. The actions taken by the Securities and Exchange Commission (SEC) acted as a message to other businesses, he pointed out, inside the same industry as one another. Everyone was going to be targeted by them. XRP will be given to Stuart Alderoty. Even though it has been going on for almost 4 years, Ripple's legal battle has become even more relevant as it is about to be heard by the Second Circuit Court of Appeals. The legal conflict between Ripple Labs and the SEC consequences for other companies has been going on for almost 4 years. Within the Southern District of New York, this ruling has the potential to set a new standard of excellence, consequently guiding the manner in which courts handle securities legislation for token issuers, in the financial center of the region and possibly beyond their jurisdiction. Ripple Lab has expressed their approval of the decision that was given down by United States District Judge Liza Torres in the previous year. This ruling said that XRP is not necessarily a security on its face, and it was praised by Ripple Lab. On the other hand, not every judge has had the same viewpoint about the circumstances. In the case that was brought against Terraform Labs, the United States District Judge Jed Rakoff was not in agreement with the conclusion that the SEC had made. He refused to behave differently when it came to tokens, based on the manner in which they are sold, and rejected the approach that Judge Torres had taken just a few weeks after she had handed down her ruling, mainly due to the fact that the majority of decisions that are handed down by the Second Circuit are preserved rather than overturned. In Alderoty's opinion, the appeal that the SEC has submitted is quite likely to be unsuccessful. On Tuesday, a spokeswoman for the Securities and Exchange Commission (SEC) asserted that the ruling handed down by Judge Torres is in direct opposition to decades of precedent set by the Supreme Court and legislation pertaining to securities. This statement was a restatement of remarks that the Securities and Exchange Commission had made earlier in the month, a recent order concerning Ripple Labs that was issued by Judge Torres. Judge Torres issued an order in August that forced Ripple Lab to pay a fine of $125 million for XRP transactions that violated rules governing securities. The order was issued in response to a court order. Ripple was not only successful in obtaining $1.3 billion through the sale of unregistered securities in 2013, but the Securities and Exchange Commission also endorsed this endeavor. Stuart Alderoty, the counsel for Ripple, argues that SEC Chair Gary Gensler is aiming to maintain a fog of uncertainty over the cryptocurrency company by appealing. As an additional point of interest, he acknowledged that the decision of the Second Circuit may potentially support either Judge Torres or Judge Rakoff. To put it another way, there is a chance that it might go either way. There has been no announcement made by the Securities and Exchange Commission regarding the specific aspects of Torres' ruling that it wants to challenge. While all of this is going on, Ripple, the company that is responsible for the 7th largest cryptocurrency, is working on having its legal action ready to go. Ripple Labs' most recent cross-appeal, which was disclosed the week before, was a cross-appeal that was fairly procedural in nature. However, the company also intends to argue that, according to the law, a digital asset should only be considered in investment contracts if it comprises a contract that explains certain rights and obligations. This is something that the company hopes to do. A stablecoin, also known as a stable cryptocurrency, has been introduced by Ripple in the midst of the SEC case. A stablecoin that is primarily aimed for corporations and financial institutions has been launched by Ripple, according to an announcement that was made. To facilitate the process of carrying out transactions across international borders, it is intended to make the process of asset tokenization simpler. Additionally, it is intended to be a good match within the area of decentralized finance. The purpose of Ripple's collaboration with a number of important market participants, such as Uphold, Bitstamp, and MoonPay, was to deliver the cryptocurrency to a target audience that was somewhat more extensive. In his remarks, Brad Garlinghouse, the chief executive officer of Ripple Words, emphasized the significance of the stablecoin that was issued swiftly by Ripple. This is in accordance with what he had to say. Now, taking into consideration our first three exchanges, the obvious application and demand in accordance with the terms of a charter that was issued by the New York Trust Company, the funds will be divided. In addition, Ripple has put together an advisory committee to oversee the implementation. This group, which includes Sheila Bair, who has previously held the position of chair of the Federal Deposit Insurance Corporation, will initially be supported on the XRP ledger in addition to the Ethereum blockchain. In spite of the fact that Ripple's conflict with the SEC has been going on for 4 years, this will be the situation at the beginning. Alderity is certain that the Second Circuit will be characterized by a more rapid pace of events taking place. A decision is anticipated to be made by the absolute latest by the beginning of the year 2026, according to his expectations. As a result of the filing of briefs and the presentation of arguments by both parties, the case that Ripple is currently engaged in with the Securities and Exchange Commission is being closely monitored by the cryptocurrency community. Today, October 16th, is a critical day because the Securities and Exchange Commission (SEC) is due to file Form C. This form will provide a description of the specific aspects of the case that the SEC intends to challenge later on in the appeal process. The importance of this paper cannot be overstated. When it comes to filing its Form C, the Securities and Exchange Commission is here. It will take Ripple 7 days to submit its version, which will include the company's perspective as well as the problems it seeks to address in a cross-appeal. Ripple will have the opportunity to present its version. The arguments and techniques that each party will utilize during the protracted court conflict, which is projected to endure for a considerable amount of time, will be significantly influenced by both documents, which will play a big role in determining the arguments and strategies. Throughout the entirety of the case, there was a significant amount of conversation taking place on social media, with supporters of XRP and enthusiasts of cryptocurrencies discussing their ideas and speculating on the outcomes that could occur. If the Securities and Exchange Commission is unable to meet the deadline that was established for today, what are some of the potential outcomes that could occur? In light of the enormous stakes involved, a great number of individuals are anticipating that the Securities and Exchange Commission will meet the deadline, however, failing to meet this. Chachki was approached by a solitary individual who inquired about the same matter. The explanation that was provided was that even if the SEC fails to meet the deadline, which is today, the lawsuit will not automatically be dismissed. Ripple would continue to wait for the next action taken by the SEC before contemplating whether or not to submit a cross-appeal by missing the deadline. This would result in delays, and Ripple would continue to wait for the next step. There is a possibility that the SEC's position will be disrupted, but this will not lead to the conclusion of the study. What is going to happen next is revealed by Ripple's chief legal officer. The parties will immediately begin working together to develop a timetable for the submission of their respective legal briefs, which will take place immediately after the submission of their respective Form C filings. Immediately after that, the Securities and Exchange Commission will have a maximum of 90 days to submit its opening brief. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.